The tricky part of the law here is what rules control when a case is in federal court: the state's extra paperwork rules, or the federal court's basic rules for starting a lawsuit. In Berk v. Choy, the Supreme Court said Delaware's rule for medical malpractice cases, making a patient file a medical professional's affidavit of merit along with the complaint, does not apply in federal court. The justices said that requirement clashes with Federal Rule of Civil Procedure 8, which says a complaint only needs a short and plain statement of the claim. The court also pointed to other federal rules, like the ones tied to dismissing a case or testing the facts later on. Justice Amy Coney Barrett wrote for the court, and she was joined by Chief Justice John Roberts and Justices Thomas, Alito, Sotomayor, Kagan, Gorsuch, and Kavanaugh. Justice Ketanji Brown Jackson agreed with the outcome. So what does that mean in plain terms? If you bring this kind of Delaware medical malpractice claim in federal court, you don't have to clear Delaware's affidavit step just to get in the door, because the federal rules set the standard for what a complaint must include. Stay with us, because the line between state rules and federal rules can change how a case even gets off the ground. Nine Robes uses nonpartisan, everyday language to focus on the facts of what the Supreme Court is saying. Here, you'll find clear, concise summaries of every Supreme Court opinion, stripped of legalese and clickbait headlines. Each post breaks down the facts, explains the court's reasoning, and highlights the crucial details that often go unnoticed. It's not just about what the court decided, it's about why those decisions matter, to give you a deeper understanding of the cases that define our nation's legal landscape. These summaries are generated by AI. Be careful and consult reputable sources when in doubt. Harold Berk, a Florida resident, injured his ankle while receiving treatment at a Delaware hospital. He decided to sue Dr. Wilson Choy and Beebe Medical Center in federal court for medical malpractice, claiming they violated Delaware law. Because Berk and the defendants were from different states, he was allowed to bring his case in federal court under what's called diversity jurisdiction. Here's where things got complicated. Delaware has a law that says anyone filing a medical malpractice lawsuit must attach a special document called an affidavit of merit. This affidavit must be signed by a medical professional who confirms there are reasonable grounds to believe malpractice actually happened. Berk couldn't get a doctor to sign such an affidavit before his deadline ran out. The trial court threw out his case for failing to follow Delaware's affidavit law, and an appeals court agreed, saying that federal courts had to respect this Delaware requirement. The Supreme Court disagreed and reversed that decision by saying that Delaware's affidavit requirement doesn't apply in federal court because it conflicts with the federal rules that govern how lawsuits work. Berk's lawyer, Andrew Tutt, argued that Delaware's affidavit requirement creates unavoidable problems with multiple federal rules, especially Rule 8 and Rule 9. These federal rules establish what's called a notice pleading system. Under this system, someone filing a lawsuit only needs to provide a short and plain statement of their claim. Tutt emphasized that Delaware's law is really about procedure, meaning it's about how you file a lawsuit, not about the underlying legal rights. He pointed out that Delaware applies this affidavit rule to all malpractice suits filed in Delaware courts, no matter which state's law actually governs the case. And Delaware doesn't require this affidavit when Delaware malpractice claims are filed in other states. This shows the law is really about regulating the litigation process itself, not the underlying right to sue for malpractice. The defendant's lawyer, Frederick Yarger, pushed back by saying these conflicts were entirely hypothetical. He characterized Delaware's requirement as a substantive state regulation of medical negligence claims. He compared it to a 1949 Supreme Court case that upheld a state requirement that plaintiffs post a security bond. Yarger argued the affidavit could be enforced through existing federal mechanisms, like dismissing cases or granting early summary judgment. He emphasized that states must retain authority to regulate their own causes of action. He also stressed that medical malpractice reform, including affidavit requirements, has been an important way for states to respond to rising insurance costs. Justice Barrett wrote the opinion for 8 justices. She held that Federal Rule 8 directly answers the disputed question and therefore replaces Delaware's law. The analytical framework is straightforward. When a federal rule answers the question in dispute, it governs unless it exceeds what Congress authorized or goes beyond Congress's power to make rules. The court framed the disputed question as whether Berk's lawsuit could be dismissed because his complaint wasn't accompanied by an expert affidavit. Rule 8 answers this by saying that a plaintiff only needs to provide a short and plain statement of the claim showing that he is entitled to relief. By requiring no more than a statement of the claim, Rule 8 establishes, implicitly, but with unmistakable clarity, that evidence of the claim is not required at the pleading stage. Rule 12 reinforces this point by providing only one merits-based ground for dismissal, which is failure to state a claim, and by prohibiting courts from considering matters outside the pleadings. The court rejected the defendant's attempts to rewrite Delaware's law into a free-floating evidentiary requirement that could be enforced through inherent authority or summary judgment. Such creative rewriting found no home in the federal rules, which already prescribe the mechanism for putting plaintiffs to their proof. That mechanism is Rule 56, summary judgment, which requires adequate time for discovery. The court also rejected the argument that Rule 11 incorporates state affidavit laws. Rule 11 includes language stating that a pleading need not be verified or accompanied by an affidavit unless a rule or statute specifically states otherwise. But the court said Rule 11 governs the conduct of attorneys and people representing themselves, not third-party affidavits from medical professionals. Finally, the court said Rule 8 satisfies the Rules Enabling Act because it really regulates procedure. It determines what plaintiffs must present to the court at the beginning of litigation, regulating only the process for enforcing those rights, not the rights themselves. Justice Jackson agreed with the outcome, but disagreed about which federal rules create the conflict. She would have found the primary conflict with Rule 3, which states that a civil action is commenced by filing a complaint with the court. Delaware's law answers the same question, which is what is required to start a medical malpractice case, but demands an affidavit or extension motion before the clerk can file or docket the complaint. This creates a direct collision regarding commencement requirements. She also identified an internal inconsistency. The majority's Rule 12 analysis treats the affidavit as a matter outside the pleadings, yet its Rule 8 analysis treats the affidavit requirement as governing pleading contents. A coherent conflicts analysis cannot have it both ways, she wrote. Justice Jackson emphasized that federal rules should be interpreted with sensitivity to important state interests and regulatory policies, and that 5 justices in a previous case endorsed this approach. This decision clarifies and reinforces the framework for determining when federal rules displace state procedural requirements in cases involving parties from different states. The analysis bypasses complicated questions entirely when a federal rule is on point. Courts first ask whether a federal rule answers the question in dispute using ordinary interpretive methods, giving the rule its plain meaning. If it does, the federal rule governs unless it exceeds what Congress authorized. The validity test remains modest. The question is whether the rule really regulates procedure by governing the manner and the means by which rights are enforced. Critically, the substantive nature of a state law or its substantive purpose makes no difference to this analysis. The court has rejected every statutory challenge to a federal rule that has come before it. The disagreement between the majority and Justice Jackson highlights an important methodological tension. How broadly should courts interpret federal rules when checking for conflicts? The majority's broad reading of Rule 8, as addressing all information about the merits at the beginning of litigation, creates conflicts with any state law requiring evidentiary support before pleading closes. Justice Jackson's narrower reading, confining Rule 8 to pleading contents, would permit more state procedural requirements to coexist with federal practice. For lawyers and litigants, this case confirms that the notice pleading system established by the 1938 federal rules sets a ceiling on what federal courts can require at the complaint stage. States cannot condition access to federal court on evidentiary showings that contradict this fundamental design, regardless of how they label such requirements or what substantive purposes they serve. Medical malpractice reform through affidavit requirements remains available in state courts, but federal courts remain governed by their own procedural system. Find us online at 9robes.ai. That's the number, 9robes.ai. Like and share this podcast with friends that like to be informed. 9 Robes provides AI summaries of U.S. Supreme Court cases. AI makes mistakes. People make mistakes too. We genuinely do our best to provide you with the most accurate summaries, but our best sometimes includes errors.